Hello, everyone, and welcome to the Teskey Brief. I'm Judge Stephen Teskey, retired, and I'm starting a new series that examines one of the most important stories in American law and government today. And it's this: what happens when the lawyers entrusted to enforce justice begin to fear the very system that they serve? And this series is titled The Bar Card, The Breakdown of Justice. Now, across this series, we're going to explore why experienced prosecutors are leaving the Department of Justice, how political pressure can distort legal judgment, and why independent courts and state bars still matter, and what is lost when institutions ask for power but stop earning trust. This is not a story about personalities alone. It is a story about professional duty, constitutional guardrails, and whether the rule of law can withstand the pressures placed upon it. In this introductory episode, I'm merely introducing you to the topic and why it is relevant, and what we will be covering in this series. So before we begin, remember this, please. Titles are temporary. Power is borrowed. Integrity is tested when pressure arrives. And this is the Teskey Brief. Welcome back. I didn't set out to write this series. It started with a question. And it's a simple one. Why are so many federal prosecutors leaving the Department of Justice? Now, you might expect the usual answers, burnout, politics, better opportunities. But no, that's not what I heard. What I heard over and over again was this: I'm not risking my bar card. In other words, I ain't going to lose my license to practice law. Now, we're not talking about their job, not their title. They're worried about their license. And that's when I realized this isn't a story about turnover. It's a story about pressure. Because when prosecutors, people trained to uphold the law, start making decisions based on whether something might cost them their license, think about it. That means something inside that system at the Department of Justice has changed, and not for the good. Now, over the past year, we've seen a pattern emerge. Career prosecutors asked to bring cases they didn't believe in. Others were replaced when they refused. Some are walking away entirely. And at the same time, judges are asking questions, and hard questions, about rushed indictments, about missing procedures, about whether prosecutions are being driven by evidence or something else. But there's another side to this story that I want to talk about. What about the lawyers giving the orders? What about their supervisors, the deputies, the attorney general, the people who may never sign the filing, but they direct the others to sign it? Because you see, line prosecutors are not the only ones with bar cards, with licenses to practice law, and titles do not erase ethical duties. That question is no longer hypothetical. Think about it. Pam Bondi's out, no longer Attorney General. And now lawyers and former judges have renewed a professional misconduct complaint against her, asking whether her actions taken while she was in office as Attorney General violated the rules governing lawyers.
She was not just fired, she was exposed. And now the people who spent years watching her dismantle the Department of Justice, piece by piece, rule by rule, institution by institution, they are not letting her walk away quietly. They are filing. And this time, the complaint is not what it was before. It is bigger, stronger, built on everything she did after the last one was dismissed, built on every lie told under oath, built on every abuse committed in broad daylight from behind the most powerful law enforcement desk in the country. They kept records, all of it.
Now, think about that for a moment, okay? And I'll put a little footnote here. When they filed it a year ago, the Florida Bar has a rule that they don't process those complaints while that person is in a federally appointed position, okay? But now that she's out, right, they've renewed it.
That was then. The moment Trump fired her, The moment she stopped being a constitutionally appointed official and became a private citizen again, that rule stopped applying permanently. The armor came off, and the same organizations that filed those dismissed complaints did not wait a single day. They are refiling, not the same complaint. They described what they are preparing as a greatly enhanced and significantly stronger ethics complaint. Those words matter. That language means the original complaint, the one filed before she lied to Congress about the Epstein files, before she violated the Epstein Files Transparency Act, before she tried to indict 6 innocent members of Congress, before she issued unlawful subpoenas to harass the chairman of the Federal Reserve. That complaint is now just the foundation. Everything she did after it was dismissed gets stacked on top. Every documented lie, every manufactured prosecution, every abuse of power committed while the rule kept the bar from touching her, all of it in one complaint, filed now that nothing can shield her anymore. She lied to Congress, not carefully, not with the practiced legal hedging that creates room for interpretation later, directly, completely, on the record.
But whatever the outcome may be, the lesson is bigger than any one person. Power may delay accountability, but it does not necessarily prevent it. And if anyone thinks that kind of accountability is theoretical, oh, come on now. It isn't. We've already seen it. Lawyers who advance baseless 2020 election claims were sanctioned, suspended, or disbarred after courts and bar authorities concluded those filings lacked factual or legal support. Rudy Giuliani lost his law license after disciplinary findings that he made false and misleading statements about the election. And then there's John Eastman, just recently was disbarred in California for conduct tied to efforts to overturn the 2020 election. And then there is the suspension of Kenneth Chesebro, or there's another attorney, Jenna Ellis, suspended by the Colorado State Bar after she pled guilty to a felony conspiracy to file false documents in Georgia. And then there's also Lynn Wood, someone who I knew many years ago before I took the bench and practiced law. He was on the opposite side of a case that I was working representing the state of Georgia through the Attorney General's office. And he left the practice of law while disciplinary battles were underway.
The people coming after her now are not political operatives looking for revenge. They are attorneys, former judges, legal scholars, 2 retired Florida State Supreme Court justices, people who spent careers inside the legal system, who understand exactly what was destroyed, who know precisely what the rules say about the attorneys who destroyed it, and what the rules say, what the precedent says, clearly and repeatedly, is not ambiguous. Rudy Giuliani was investigated by the D.C. and New York bars, disbarred in both. John Eastman was investigated, disbarred. Kenneth Chesebro was investigated, disbarred. Jeffrey Clark was investigated, disbarred. These are not obscure cases buried in legal footnotes. These are the attorneys who surrounded Donald Trump's first term, who participated in the documented effort to overturn the 2020 election, and every single one of them lost their license. What Pam Bondi did as Attorney General of the United States makes what some of them did look restrained.
The courtroom was only the first judgment, ladies and gentlemen. The bar came later. Look, I have no doubt that what happened to these lawyers that I just mentioned is weighing heavily on the minds of those U.S. prosecutors who resigned or were fired for insubordination by their refusal to file a false and frivolous complaint or other document, like, what we call pleadings among us lawyers. From experience, I think there are too many people who are not aware of what happened to those lawyers that I just referenced. And many of those unaware are people who hear a narrative that the 2020 election was fraudulent and that the judiciary is part of it, like dismissing all the cases, right? So they become suspicious that there's a conspiracy. Let me share one of many stories that happened to me while out in public. And what happened in this story could happen many times over, and it did. It was just a different person, different name, but the same story. So my wife and I went to a restaurant one evening. The wait for a table was long, so we took a couple open seats at the bar. A few moments later, a man wearing a red MAGA hat sat beside me. We exchanged greetings, made some small talk, and before long, he asked me what I did for a living. I told him I was a lawyer and a retired judge. The moment I said judge, he lit up. He leaned in, asked the question I have heard many times from devoted Trump supporters. Why did the courts dismiss all the election fraud cases? Didn't it seem like a conspiracy against Trump? Well, this was not my first rodeo, and I answered the way I usually do, with respect. I told him, I understood how someone without legal training might see it that way. If all you hear is that the cases were thrown out, it can sound suspicious. He said what bothered him most, though, was that no jury ever heard the evidence. To him, that felt unfair, and I get it. So I explained something lawyers learn early and judges apply every day. Not every case gets to trial. Before a jury is ever seated, the person filing the lawsuit must first show, enough factual allegations and legal basis to justify using the court's time and the public's resources. And that usually comes on, one of the parties, typically the defendant. In this case, in these election fraud cases, those lawyers filed a motion to dismiss for failure to state a claim or something similar to that. Now, the purpose of that is to streamline the case, right? Okay, let's not, why bring a jury together? Why spend taxpayer, and it costs a lot of money to get jurors there, okay? Why do that if there's not even a case for the jury to hear? Now, if the plaintiffs in this case, the ones who on behalf of Trump or whoever brought these claims alleging that the 2020 election was fraudulent, if they cannot provide some evidence that it's worth going to trial, the judge can dismiss the case, right? That's a pretrial motion. That's not corruption. That is how the system prevents meritless cases from consuming taxpayer dollars and harming the people accused. He listened politely to what I said, but I could tell that I had not moved the needle. So I asked him a different question. Did you know that many of the lawyers who filed those election fraud lawsuits were later investigated by their state bars, that is, the entity that licensed them, okay? And they were disciplined, suspended, or disbarred for filing false or unsupported claims. Now, he looked genuinely surprised at that. He said he had never heard that. So I pulled out my phone. I searched for lawyers disciplined over the 2020 election fraud claims and showed him the results. I explained that lawyers are not free to file anything they want. They are officers of the court. They raise their right hand before a judge after they pass the bar, okay, and they swore an oath to abide by the rules of ethics of the state bar, right? And if they didn't, they're violating an oath of office. They have ethical duties. If they knowingly file false claims or bring cases without a good faith factual basis, they can lose the privilege to practice law. It's that simple. It's like practicing medicine, okay? You can lose your license to practice medicine if you commit malpractice. And filing a false claim is malpractice. Now, that got his attention, right? He looked back at me and he said he was glad he had sat down next to me because he had learned something no one had ever told him. That conversation has happened in one form or another many times. Ladies and gentlemen, it reveals something important. Many citizens are not rejecting the legal system because they are irrational or malicious. Often they simply have never been told how the system actually works. They know the headlines, they know the slogans, they know the outrage. What they often do not know is the process. They do not know why judges dismiss cases before trial. They do not know the difference between losing a case and filing an unethical one. They do not know that courts decide lawsuits, but state bars decide whether lawyers abused the privilege to bring them. The gap between perception and understanding is where distrust grows, ladies and gentlemen. And helping close that gap is one reason I'm doing this series. But there is a third layer to this story, and it's power. Many of these ethical conflicts did not appear out of thin air. They arose in a political environment where the President of the United States repeatedly and publicly demanded that prosecutors go after his enemies. And when those demands come from the top, they echo all the way down the chain of command. Because if success isn't measured by pleasing power, instead of proving a case, the institution itself is in danger, especially a legal one, with all those rules of ethics they must comply with. And here's the irony. If a senior official is removed not for questionable directives, but for failing to carry them out successfully, the pressure on whoever comes next only grows. And that's the irony of this. Miss Bondi was trying to carry out directives of the President of the United States to go after his enemies. She wasn't successful at it because you know what? When they're unethical and it's frivolous, you're likely not going to be successful. But that's why he fired her. Wasn't because she was being unethical and filing frivolous claims, as alleged in the complaint down in Florida. All right. You see, aggression gets rewarded, and that's what's happening right now. All of a sudden, once she gets fired, the interim U.S. Attorney General, Todd Blanche, all of a sudden, we're seeing all these indictments happening. Okay. Investigations happening. Why? Because if he doesn't show proof of that, he's out the door too. Now, so Todd Blanche steps in. He's a seasoned lawyer. He's an experienced advocate. And the question becomes the same one facing everyone else in the story. Will judgment lead or will pressure lead? Because every lawyer in the chain of command eventually faces the same truth. A government title is temporary. A bar license follows you home. The president can appoint lawyers to positions of power. The president can demand loyalty. The president can demand speed, but the president does not control the state bars that license lawyers. And that may be one of the last checks the public still has. Because here's the rule. The one every prosecutor learns. You don't start with a person and go looking for a crime. You start with the evidence and then decide if there's a case. But what happens when that order is reversed? What happens when the target comes first and the investigation comes second? When winning the case isn't the point, but putting someone through the process is. This series is not about relitigating individual cases. It's not about politics. It's about something more fundamental, the difference between a justice system driven by evidence and one driven by outcome. The difference between public power and professional accountability. We're going to walk through, number one, what prosecution is supposed to look like. 2, what career prosecutors are saying privately and publicly. 3, what courts are beginning to question. 4, why some lawyers choose to leave rather than comply. 5th, what happens to lawyers who give unethical orders. And lastly, and why professional accountability can outlast political power. Because when prosecutors have to ask, if I sign this, will I still have my license tomorrow? The system is under strain, folks. And when leaders have to ask, what happens when I no longer have this title? Accountability may just be beginning. All right. The most dangerous shift in any justice system is not when cases are lost. It's when cases are brought that should never have been filed at all. And when power ends, the rules of the profession still remain. This series is about that moment. This is the bar card and the breakdown of justice. Justice isn't just what we decide, ladies and gentlemen. It's how we decide it and who answers for it when the power is gone. Thank you for listening. And until the next episode, be safe and take care. Goodbye.